Ms. Albright, you seem to be a bit emotional.
Yeah, I've been trying to get my attorney to meet with me before court for multiple times now. I'm not understanding why I'm not being sentenced today.
I think
Judge,
he's making a request to file a departure motion. You're presumptive prison on this case.
I'm presumptive probation.
Actually, you're not.
What? I was never even able to meet with this Carrie Seeley on a PSI. She never showed up. She was a no-show to our meeting here, so I don't understand what's going on.
All right. Well, we're going to continue your sentencing. That will allow more time for whatever conferencing is necessary to Monday, January 6th at 9 o'clock. According to the face sheet of the pre-sentence report, there's a special rule application here. Ms. Albright, you are presumptive prison because this is your third or subsequent felony drug possession conviction.
I've had my record expunged of all those things before, Your Honor. I don't understand.
All right. Further explanation obviously needs to take place between you and your attorney. Mr. Watts, do you want an opportunity to confer with Ms. Albright and Ms. right now by Zoom? We can leave the meeting open and put you in a breakout room.
I'm fine with doing that, Your Honor.
Okay. This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Elizabeth Louise Albright, case number 2024 CR 76. Brett Sweeney appearing for the state of Kansas. James Watts as defense counsel. Defendant Albright appearing from the Butler County Jail Zoom location. This matter comes before the court at this time for sentencing. The court's docket notes indicate that this defendant appeared before this court on October the 29th of 2024. At that time, she pled guilty to possession of methamphetamine, a level 5 drug felony. Sentencing originally was set for December the 30th. The notes from December 30th indicate that sentence was not pronounced on that date. Mr. Watts, on behalf of his client, had requested a continuance to file a departure motion, as this is a presumptive prison case. That request was granted, and the sentencing in this case was reset to today.
Statutory provision for persons who are, frankly, in Ms. Albright's category. She's not had prior Senate bill treatment. The statute, I use the language of the statute here, is that a person that qualifies, and Ms. Albright falls in this qualification under 216805 F1, shall participate in an intensive substance abuse treatment program of at least 4 months duration. I know Your Honor is well aware of this provision, and Your Honor is also well aware that following that treatment program, a person would then be referred back to the court for possible placement in the community. As Your Honor is further aware, that treatment program, that provision in the has never been funded by the legislature. The legislature contemplates a treatment program for persons in Ms. Albright's circumstances. It does not exist because the legislature has not funded it. In the alternative, Ms. Albright has obtained a evaluation from Seventh Direction. I believe I forwarded same to the court, which indicates she qualifies for, I read this correctly, intensive outpatient level 2 services. I did speak with Seventh Direction. That qualification or that diagnosis is available not only at Seventh Direction, but a number of other treatment facilities around the state. It's a standardized diagnosis that Seventh Direction and other treatment providers use. There is a treatment program available that she can step into and begin very shortly at any time. The only reason she's not in it now is she's sitting in the county jail, and obviously she cannot do that treatment program while she's in county jail. That treatment program provides what the legislation says should exist, but does not, because the legislature never funded it. And I would note that a departure here does not, well, let's put it this way. It puts the impetus entirely on Ms. Albright to either succeed or fail. There are no dips or dunks. She's not required to get any breaks. She either successfully completes this probation or she does not. If she does not, I don't know how I'd argue to do anything other to send her back to the Department of Corrections. I'm sure I'd try to craft that argument at that time, but at this point, it's hard to imagine what that might be. So if she fails on this, it will fall squarely on Ms. Albright's shoulders to either do it or not. And I would note, and Ms. Albright pointed out, that as Your Honor is sure to remind us, Ms. Albright had a failure to appear. She did not, however, simply disappear. She was in contact with her bondsman the entire time. Her bondsman contacted me. I have an email from him of the date on that, July 22nd. She ended up turning herself back in shortly after that time. I don't remember the exact date she turned herself back in, but she ended up turning herself back in to the court, and frankly has been in custody ever since. So looks like August 25 is when she turned herself back in. So for all of those reasons, well, I should mention one other thing. Should the probation be granted, she'd be going off to Jackson County. That's just north of Topeka. She indicates she has a job in Sabetha, Kansas, which is even further north, laying fiber optic cable. It will require transfer of her probation. That's a fairly routine matter. But she'll simply, and as I revised her, she will have to make sure she reports probation here and continues to report here until such time as that transfer is done. Your Honor, given the age of her prior convictions, given that she's already got a treatment evaluation done and ready to step into that program, and given that the legislature has declined to fund an alternative, I would argue that she is a good candidate, in fact, an excellent candidate for probation in this matter. Would ask the court to consider departing to do so. Thank you.
Very well, Mr. Watts, I understand your position. Mr. Sweeney, at this time, I'll ask the state to provide whatever commentary is appropriate regarding the departure motion, and also ask you to recommend an appropriate sentence in the case.
Thank you, Your Honor. Your Honor, as it relates to the departure motion, I mean, I guess I'll just say this. The state had agreed to recommend the presumption, which is pretty standard in most all of our plea agreements. That being said, I can also tell the court, and I think the reason behind that is just like, well, if the legislature has this intention behind a third strike rule, that's what we're going to recommend. That being said, there's not a whole lot that's terribly remarkable about this case. It's not a lot of methamphetamine, or I guess in this case, an opiate that's found. But in any event, I guess it is methamphetamine, but in any event, it is a third strike, and so the state's going to be recommending the presumption. The state would be recommending the mid-box, standard 20 months in Department of Corrections.
Court hereby establishes count 1 as the base sentence in the case for the offense of possession of methamphetamine, a severity level 5, non-person drug felony, on which the defendant has a criminal history score of E, thus placing her in grid box 5, drug E. The court hereby sentences the defendant to a term of 10 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. The court has considered but declines to impose a fine in this particular case. Court does note in grid box 5, drug E, under normal circumstances, this might be a case where the court would have the authority to grant probation in the case from the outset. However, I will note the application of a special rule in this case. This is a third or subsequent felony drug possession, in this case, all for possession of methamphetamine. Therefore, there is a special rule which presumes prison in this case. The court does note in response to determining that this case was a presumptive prison case, Mr. Watts, on behalf of his client, has filed a motion for dispositional or durational departure. This court finds at this time that this defendant, in the view of this court, would present no reasonable likelihood of success in a community-based program, and the court will reject the request for a dispositional departure and order prison in this case. Implicit in the court's earlier announcement of its ruling, or where'd the defendant go? I need to be able to see you on screen, ma'am. Again, implicit in the court's earlier ruling, the court has announced a sentence of 10 months, which is actually half of what the attorneys jointly recommended to this court. Implicit in that is that the court does find that the reasons stated in the motion and argued here by Mr. Watts does support a durational departure. The court does note that the statutory scheme would seem to indicate that the defendant would go to the Secretary of Corrections treatment program for at least 4 months, and then is subject to a modification of the sentence by the court. Since that apparent statutory scheme has not been funded and is not available, what this court will do will almost presuppose that Ms. Albright will earn her good time credit and would have had a successful review following treatment. The court knows she's already served about 4.5 months of the 10-month sentence announced. Court would also presuppose she can earn about another month of good time credit, which would leave approximately 4 to 4.5 months for her to be in Department of Corrections custody, consistent somewhat with the statutory scheme. The court will order prison in this case. Mr. Sweeney, I'm going over my notes from the sentencing, and I'm going to ask you, are there other sentencing-related matters that you believe the court still needs to address?
Your Honor, one additional sentencing matter, and this is a message that I'm getting from Ms. Shelia, but it appears that she did have a couple of other short stints that are going to add some time to the jail time credit, one from February 17th of this year to February 21st, and one from July 17th to August 7th of this year. And those are going to add, it looks like, a total of 25 days. It looks like from our math, that would bring the total jail time credit to 159.
Okay, begging the question, why wasn't those periods included in the original computation?
I'm gonna.
Well, Ms. Sealing needs to answer that one.
That was my error, Your Honor. I do apologize.
She's entitled to every jail time credit day that the law allows. So if that needs to be corrected, included in the sentencing journal entry, please do so, Mr. Sweeney. Thank you for that announcement. All right. Mr. Watts, are you aware of anything further that the court needs to address at this time?
No, Your Honor, I could do a brief breakout just to wrap things up.
Ms. Albright, it's in your best interest to earn every good time credit day that you're eligible for while you're in Department of Corrections custody to earn your earliest possible release date. And I hope that somehow you can be successful in the community once you're released, and that you can leave this horrible drug of methamphetamine alone for the rest of your life, because it certainly hasn't done you any favors thus far. All right. I think we can accommodate that breakout session, Mr. Watts. We'll try to do that. At this time, the court will recess